All right. Well, good morning or good afternoon to everybody, depending on where you're joining us from today. Today, we're going to be talking about workplace drug screening compliance, providing a legal update on all things mostly cannabis related, but also have a few other items to discuss. Just quick housekeeping items. Everyone that's attending today will receive a copy of today's presentation, so we'll provide that as a follow-up via email after today's presentation. We certainly encourage your questions. We are here hopefully to educate and inform, and certainly want to answer as many questions as we possibly can. We certainly encourage you to use the chat box throughout the conversation, and we do have some time carved out at the end for to answer your questions, but we may address them during the conversation. My name is Nick Hartman. I'm the managing partner and consultant here at the Drug Screening Compliance Institute. And joining me is my colleague, Bill Judge, our lead research attorney. And today's conversation presentation is brought to you by Chase Safety, our partners in workplace drug and alcohol screening compliance. We thank Chase for having us here today and for hosting today's conversation. Now, while Bill is a lawyer, we're going to try our best not to hold that against him in today's conversation.
Thank you.
But it's important to note that DSCI is not a law firm. Please do not construe this information as legal advice. As you can imagine, everyone's employment or employee situation is different. So please make sure you're utilizing your subject matter expertise and the legal resources prior to taking any action based on today's information. All right. Got the legalese away, and we can get started with the real content here. We have a pretty aggressive agenda. We're going to do a quick recap of legal changes that have happened over the last year. We're going to take a look at the latest industry data on substance use that's driving these issues. We're going to spend the majority of our conversation on new legal limitations that employers are having to face with these new laws that are coming out that specifically use legal terms like off-duty use or use while at work, and hopefully bring both a legal and practical perspective for you on that. And then we're going to dive into some evolving drug testing strategies as things are changing and evolving, and of course, leave you with some guidance and action items. And again, as I mentioned, we have some time carved out for some Q&A at the end. But again, please feel free to submit your questions in the chat. All right. So, Bill, it wasn't a huge year for drug testing changes in the workplace, but we definitely obviously came into an election year here in November. And out of that came a few interesting items to note.
Yeah, there was a lot more threats than there were results.
I mean, you and I here at DSCI, we track all the different bills and legislative issues and court cases that happen all the time, and we watch them as they're initially hatched, and then most often as they fizzle out through the legal process. But some become law, and then of course we have to dive in and figure out the details, and most importantly, interpret what those impacts are to the workplace. Well. We saw that Nebraska voters approved two different medical marijuana initiatives. And of course, we heard some rumblings even before Election Day that there was a legal challenge to that because of the fact that there was two initiatives on the ballot, and there may be confusing language or whether they even qualified. So as it stands right now, there is a pending legal challenge to Nebraska's new medical marijuana law. Diving into the details of that law, we didn't see any specific employer limitations as it's been drafted, although as you'll learn in today's conversation, medical marijuana patients still may be able to find employment protections regarding their underlying medical issue for which they were, of course, authorized to use medical cannabis. So we'll dive into that in a little bit more detail.
Right.
And then the hotly contested efforts in Florida, also in North Dakota and South Dakota, to legalize the adult use of marijuana. All those initiatives failed or rejected. Florida was pretty close. I think there was something about $200+ million on either side. It was a big fight down there in Florida. And I know that's not their first time trying to get this across the line, but again, it was rejected in all three of those states. We know that lawmakers in both Hawaii and Wisconsin are actively working on adult use marijuana legalization efforts. And Bill, your opinion is Florida, North Dakota, South Dakota will probably have similar efforts in the future as well.
They are already, the groups behind them are already drafting and threatening to come back again in the mid-year election. So,
Yep, yep. So again, those are what we're focusing on, as well as other municipalities that are trying to either decriminalize or bring in workplace protections for those that use the drug. So, um, couple of quick items on the federal side. We know that it's dominating the headlines right now of the DEA proposal working with the FDA to reschedule cannabis, either from a Schedule 1 to a Schedule 3, or maybe even removing it entirely. With a new administration at hand, who knows what's exactly going to happen there, but it's something that we're keeping a track of. And of course, once that decision's made, we can accurately diagnose what the impacts to the workplace will be. And then also something significant that happened just last Monday or this Monday here. Clearinghouse 2 went into effect for those that aren't aware. For those regulated by the Federal Motor Carrier Safety Administration or FMCSA, our nation's truck drivers. There's a clearinghouse database for those that have drug or alcohol testing violations. The Clearinghouse 2 rolled out on Monday, which was an enhanced integration now with state Department of Licensing databases. So for the nearly 200,000 drivers that were currently in a prohibited status with the clearinghouse, meaning they had some kind of violation that they needed to clear up. That integration now went live, and all those CDLs were now revoked in state databases. And of course, in order for those drivers to get back into a good status, they have to follow the clearinghouse treatment, and then of course return back to duty requirements to get their CDLs enacted. But again, a pretty big impact when you're talking about almost over 200,000 drivers, Bill.
yeah, for an industry already short of drivers, this is going to hit hard.
Yeah, yeah. But I think that does it for our legal updates, what have happened over the last year. Um, Switching over the conversation a little bit to the latest data provided by our friends at Quest Diagnostics, the nation's leading provider of workplace drug testing laboratory services. Each year they share with us in their drug testing index positive drug testing data for the workplace. And Bill, correct me, we do about 50 million drug tests
Yeah,
a year in our country. Is that correct?
yeah, what we do all the time is research these issues, and we can pinpoint some definite authority that shows that, and it fluctuates all the time, but we can say that between 45 and 50 million drug tests are done related to the workplace every year in this country. That's a lot of drug tests. And
About
with a 4.6% positivity rate, that's a lot of people looking for their next job or having to go through treatment or whatever the case may be.
Yeah, and as Quest kind of pointed out, it's a 20-year high. So 4.6% of those somewhere around 50 million or so drug tests. That's a lot of individuals that are testing positive for some illicit substance. And of course, these are individuals in our nation's workforces today. Also, it's important to note, Bill, I think there's about 8 million of those drug tests are done for
Yeah,
federally regulated drug
yeah,
tests, right?
we just wrote an article recently about we need in this country, when we're talking about drug testing, to take our federal blinders off, because only about 13% of those tests are federally mandated. The rest are governed by some state or municipal law.
Yeah.
So employers are making a huge mistake if they, for instance, take their DOT drug testing policies and apply it to non-regulated people. That is a recipe for disaster.
Yeah, I agree. It's a gigantic no-no. Taking a look a little bit more at the data here, picking on marijuana for a moment. No big surprise here, but the positivity rate in the general workforce increased more than 45% over the last 5 years. I guess as you continue to authorize its use, individuals are going to continue to use it. It's going to show up in the nation's workforces.
Right.
Which did come to a surprise to us was the positivity rate in post-accident drug tests for marijuana increased 114% from 2015 to 2023. And Bill, do you want
Yeah.
to elaborate on that?
Yeah, it's a surprise, but perhaps not a huge surprise. And you and I've been talking about this, writing about this for a couple of years. And Quest uh, wrote about it as well when they reported this increase of 114%. If you, as an employer, drop marijuana from your panel from pre-employment testing, that doesn't mean it goes away. You're going to see it somewhere else. And where what this number of 114% post-accident test shows us is that it's showing up in post-employment situations like reasonable suspicion and post-accident. So you might want to reconsider that.
Yeah, working with our clients every day, we get this question on whether or not they should continue screening for marijuana, and they're scared of the different laws that are out there and may have the perception that they're not allowed to test for marijuana, which in our conversation we'll dive into those details that it's not
Yeah,
actually very limited prohibitions exist for testing for cannabis. It's more on the what actions you take based off of a positive.
right.
And like I said, we'll get into those details, but here we have the cause and effect of employers kind of putting the proverbial head in the sand and not screening for it pre-hire. It's still going to rear its ugly head post-hire, and this is the
Yeah.
evidence of that, right?
We hear about it all the time, like you said, and there's only a handful of jurisdictions that prohibit or limit pre-employment marijuana testing. Mostly, as you said, it's a question of what the consequences can be, shall be,
Right.
if you find someone positive. So, you know, don't think, and we hear it all the time. People say to us, "Well, the law says we can't test," and in fact, the law says you can't discriminate. There's a huge difference between those two.
Yeah, do our best to define that and make that a little bit more clear for everybody. Also, not a surprise in states that authorize the illegal adult use of marijuana, we saw an increase of about 118%, and in states that authorize its use for medical reasons, a nearly 70% increase dating back to 2012 to 2020. Again, not a surprise you authorize its use. We're going to start seeing some positives. Bill loves this stat. In states that have no legalized marijuana use at all, which is a very limited number of states right now, the positivity rate still increased by nearly 60% 2012 to 2021. And in the latest Quest Diagnostics data, up another 6.5%. So,
Yeah,
again, regardless if it's legal or not, it's being used.
not a huge surprise. It's legal to use if you're an adult here in Illinois, where I am.
Mhm.
It's not legal in Iowa, so not a big surprise. Folks will go across the bridge from Iowa to Illinois to buy some marijuana.
That's right. That's right. We saw all the different stats during the pandemic about how alcohol and marijuana sales were skyrocketing as Americans self-medicated during those dark times, and hopefully we're slowly coming out of that. But again, with the positivity rates, this is a direct reflection that that use is still happening to some degree. And we're not just picking on cannabis in this conversation. The Quest Diagnostics data also showed an uptick in both amphetamine and cocaine positives. So again, other common drugs of abuse are showing an increase in use. Now, one thing that did alarm us, and we definitely want to take a moment to address, is Quest shared for the very first time ever drug test cheating in urine drug testings, and there's data showed a surge by 633% just over the last year in individuals trying to alter, adulterate, or substitute their urine specimens. That's a pretty alarming stat, Bill.
Yeah, not a big surprise when you have 4.6% positivity rate. Folks, the increased use of marijuana drives people to look for ways to avoid testing positive on a workplace drug test. I had a relative this summer young person who was about to start a job in September, and they wanted to know how they could avoid testing positive. And I said, well, you could stop. Uh, they probably never thought about that. But anyway,
Novel idea. Stop using
yeah,
the substance. Yeah, yeah,
yeah,
no big deal.
stop using and anyway.
But it
Uh,
just shows the market that's out there. You know that you can go online, you can go to your local gas station or drugstore and get these different solutions that can help you beat the drug test for a urine drug test. So
Allegedly, yeah.
They're amply available. Obviously, they're being used, and collectors are seeing them at the collection sites, which will kind of tie into our conversation on how drug test is evolving. And we'll look to other alternative specimen methods, such as oral fluid, which we'll harp on here in later on in the
Yeah,
conversation.
absolutely.
Yeah. So covering a few, diving into some federal and state specifics. Very little bit of our conversation is going to be surrounding federal workforces. I know we had some federal updates. This slide here will bring home the fact that anybody that's in a federally regulated, safety-sensitive position cannot use the fact that marijuana is legal for either adult or medical use, or even their use of cannabidiol as an excuse to overturn a DOT regulated positive drug test for cannabis.
And by the way, that applies not only to a truck driver, but to an employee working directly under a federal contract. So it's federal
Federal contracts or
contractors as
grants.
well as
Yeah.
regulated. Yeah.
Totally agree. So again, at the federal level, it's still a Schedule One drug. The DOT has made it very, very clear that those that are using or trying to argue their legal use will not be acceptable at the federal level. And for those that are interested, the DOT has those letters and notifications right on their website. You feel free to download those or reach out to us and we'll provide it for you. But again, at the federal level, marijuana is still not an excuse. So again, it brings up a great point to make sure that you're discerning your policy, your procedures, and the collection methods between your federally regulated employees and your non-federally regulated employees, and making sure you're not following one process or the other. To Bill's point earlier, you're going to find yourself in a lot of trouble if you do that.
Yeah.
All right. So really digging into the meat of what we want to talk about today is the trend in legal limitations for workplace drug testing. And we use a lot of legal terms like off-duty use or use while at work and trying to figure out the applicability of that. So right now, as we sit here today, we have 38 states, maybe 39 if Nebraska makes their decision and gets ruled in their favor to allow it. But that 38 states, Washington, D.C., and a few U.S. territories that authorize the medical use of cannabis for a various amount of reasons, from common things like chronic pain and anxiety to more debilitating things like cancer, epilepsy, those kind of things. There are 24 states, Washington, D.C., and a few U.S. territories that authorize the adult use of marijuana for those 21 years or older. There are 18 states now that authorize the medical use of cannabidiol, specifically CBD or low THC oils, again, for various different medical reasons or qualifications in those states.
And by the way, those are states that have specific laws addressing that issue. It doesn't deal with the now legal hemp derived CBD, which most states either have or are in the process of developing.
It's a great point, Bill, because we know that we've seen all the stories about how CBD products are readily available. You can go to your local drugstore, smoke shop, and what you call the fabulous World Wide Web, and purchase these products. There's other alternative products like Delta 8, Delta 10, all those type of things. Those don't even play a role here from a legislative perspective.
Well, and it makes sense because CBD is allegedly or supposedly not supposed to test positive. Because lawful, legal CBD cannot contain any more than 0.3% of THC, which is what we do test for. So theoretically, you shouldn't be able to test positive if you're using authorized CBD. Unfortunately, there's just not enough regulation, not enough monitoring, shall we say. Regulation's a bad term these days.
Quality control, buddy.
Quality control on the products that might be available in Bob's General Store on the corner. Yeah. And so you may be using a CBD product which you consider or think is lawful. It may even say so on the packaging that it's lawful, when in fact it's got way too much THC in it.
Certainly buyer beware on that type of stuff. If your life or livelihood could be jeopardized by failing a drug test for marijuana, we certainly discourage the use of cannabidiol products for that same reason.
Yeah, we have a case now pending before the U.S. Supreme Court involving a truck driver who claims that his marijuana positive was the result of his use of what he thought was lawful CBD, when in fact it was not.
as advertised as pure CBD, right, Bill?
Yeah, whatever pure means, yes.
So really the big point here is that you look at this map and you got to understand that the language of these laws varies dramatically. And as you can see, there really isn't any states aside from our friends in Idaho that where employers can find any relief from this issue. So it's important to kind of understand the differences and what applies to your program. So as we're going to talk about here, there's a gigantic trend in states and even cities passing laws that are providing more employment protections for employees or applicants who lawfully use cannabis under state law. Uh, these laws will greatly impact the who, what, when, where, why, and how you can test for the product for cannabis, and most importantly, what disciplines you can impose on a marijuana positive. And Bill, we talk about these terms like lawful activities, lawful products, these different laws that have been on the books for decades, but they originally were stemmed out of like nicotine, tobacco, and cigarette era, right?
Exactly. Back in the 1970s, and I was involved in the law here in Illinois and in writing some of the language for it. Um, there are about 19 states that prohibit discrimination by employers against an employee's lawful use of a lawful product. Okay, there's quite a bit of room in there for discussion in terms of what's a lawful product and what's lawful use. And courts have come down on both sides of this. There was a well-known case out of Colorado with the Supreme Court, and it's called the Coates decision. And the Supreme Court essentially sided for the employer when they terminated somebody who argued that, wait, I was using a lawful product off duty. The court said, okay, marijuana may be lawful under Colorado law, but it's not lawful under federal law. Therefore, we consider it not to be lawful. So you really have to be careful and not only look at the state's language of their statute, but how are the courts looking at it?
Because that has been interpreted differently. You're absolutely right.
Yeah,
And
absolutely.
who knew 30 years ago that marijuana would be a lawful product falling under the guise of that law, right? So
Never thought it was addressing, like you said, smokers and smokers' rights to use that product, that lawful product off duty.
yeah.
Was basically an insurance legislation. It had nothing to do with anybody thinking that marijuana might be legal someday.
Yeah. And certainly what's been dominating our time recently is the trend in state laws and even municipal laws that are now trying to carve out how employers test and really kind of create laws backing or maybe foreshadowing, I don't know, the science of cannabis testing.
Yeah.
And they're limiting employers from screening for non-impairing cannabis metabolites.
Yeah,
Uh,
exactly. I mean, it's in some ways it's not appropriate any longer to simply say you tested positive for marijuana. You have to kind of break that down and say, well, what metabolite? Was it delta 9? Was it hydroxy THC? Was it carboxy T? What metabolite did I test positive for? Because that may make a difference depending on what state you're in.
And we're going to dive into that in great detail because it makes a huge difference. And it absolutely is a trend that Bill and I see continuing throughout additional states and municipalities. But just to give you an idea, some states and cities limit or prohibit testing for marijuana as a condition of a pre employment test. California, Connecticut, Nevada, New York, New Jersey, the city of Pittsburgh and Philadelphia, and then also where I sit here in Washington state. Now, Bill, we're going to harp a little bit on New York State because I know that we got quite a few from our audience that had questions on New York State laws. And as it stands right now, at the state level, they prohibit testing for cannabis outside that of reasonable suspicion, signs and symptoms of potential impairment, right?
Well, exactly, but we have to be really, really careful in New York because what happened was the legislature came in and when they approved adult use of marijuana, they combined that law under a single law dealing with both medical marijuana and adult use of marijuana. They did not wipe out any of the protections for medical marijuana patients. In fact, they enhanced it. So for a medical marijuana patient, you have to be really careful not to discriminate against them simply because they are a medical marijuana patient. And medical marijuana patients under New York law are by definition considered to be disabled. which gives them all the protections under what's called Article 15, the Human Rights Statute in New York. So just because somebody's a medical marijuana patient, they test positive, doesn't mean that you can automatically deny them employment or terminate them. You've got to make certain that you cannot accommodate their use of that drug in the workplace, or the underlying medical condition is more accurate, frankly.
It's an absolutely critical step that you need to take prior to denying employment or terminating somebody, right?
Yes.
For those employers in the New York City limits or the New York City proper, marijuana testing, of course, is limited as well, but they do have some safety sensitive exceptions there.
They do indeed. And you got to be very careful and look at the carve out that's been provided to see if, in fact, your workers qualify under any of those safety sensitive carve outs.
Yeah. We also have 8 different states we're tracking that either limit or prohibit an employer's action or discrimination against the lawful marijuana use. Again, a legal term here, outside the workplace: Arizona, California, Connecticut, Maine, Minnesota, New York, Montana, and Washington. But there are dozens of other states that have similar limitations that are implied because they use the same kind of terminology, right? Like at work or while at work or while off duty.
Yeah, 28 states to be exact. So you combine that with the 8 states that have very specific rules about not discriminating for off-duty use, and you look at states like Illinois, where I am, and it says that employers are authorized to take action if they find someone to be using or under the influence at work. Okay. Now, to me, that's kind of the same thing as having specific language that says you can't discriminate for off-duty use, because you're only authorized to use if you find them using or under the influence at work. How do you do that?
Yeah, I'm going to spoil one of our slides we have later, but there is no methodology. There is no per se limit. There's no device out there that can determine if someone's under the influence or high right now from cannabis.
Correct.
So now we're dealing with legal language like this, making that direct correlation. So we'll hopefully give you some tips on how to bridge that gap as we continue the conversation. So shifting over here to our friends in New Jersey, they came in and made a big splash about the new inception of a wire. Well, what the heck is a wire, right? We get that question all the dang time. And the acronym stands for Workplace Impairment Recognition Expert. And essentially, lawmakers in New Jersey tried to create a retirement plan for their local law enforcement. No, really what it does is it requires someone who's properly trained to recognize the signs and symptoms of workplace impairment and have that evaluation prior to administering a drug test.
Yeah, so the statute says almost with pride, we're not going to take away an employer's ability to test for, pre-employment, reasonable suspicion, random, et cetera. But you have to do it in conjunction with a wire telling you that there is a basis for doing so. How you do that for pre-employment is beyond me.
Yeah, even the state doesn't even know how they do that because when they talk about when they brought out the wire requirements, they have, of course, said that in the future we'll figure out what the training qualifications and program will be, and they've still stuttered on that right now. And the most recent guidance that they provided us is just utilizing those that are trained to recognize the signs and symptoms of workplace substance use. So essentially, reasonable suspicion, right?
Yeah, essentially, do what you've been doing all along.
So something we're keeping a track of. We'll see how that evolves. But employers in New Jersey should definitely, managers and supervisors should be trained to recognize the signs and symptoms to meet the conditions of the law there.
Yeah, now we have a copy of that guidance if you'd like to see it.
And Bill has mentioned one point of caution for anyone dealing with medical marijuana. We certainly see a growing trend where applicants and employees are suing their employers under state disability discrimination laws. So even in states that don't afford any employee protections for those that lawfully use medical cannabis, they still may be able to find protections, as Bill mentioned, under state human rights laws, protecting their underlying medical condition for which they use medical cannabis. And Bill, we could use Barbudo out of Massachusetts,
Yep.
and of course the state of New York, as you already mentioned, they're automatically determined to be disabled individuals, thus afforded human rights.
Well, and there are other court decisions besides New York and Massachusetts. You look at Connecticut, Delaware, in some other states. Essentially, what happened in the Barbudo decision is an employee was dismissed for a positive drug test and claimed to be protected under the state's medical marijuana law as a medical marijuana patient. The state Supreme Judicial Court in Massachusetts said, no, you don't have a right to sue your employer under the medical marijuana law. The legislature didn't give you that right. But they said, however, you may have a cause of action under the state disability discrimination law. So go on over there and sue them. So, it was, yeah, you can't sue here, but you can sue over here.
Got some free legal advice in the court proceedings.
Yeah,
it's great.
exactly right.
But really the point here is that employers need to be prepared in these situations to have an interactive conversation with that individual to make sure that their underlying medical condition can be reasonably accommodated or not in the workplace before they take any adverse employment action.
One other very important or interesting point made by the Supreme Judicial Court in Massachusetts was they said, because marijuana is legal to use for medical marijuana patients, it should be treated like any other prescribed medicine. Now think about that.
Fascinating.
Think about that. And there are other states that have said the same thing. And in fact, you've got in South Dakota the law that specifically says medical marijuana patients shall be treated as using any other prescribed medication. So very interesting.
These lawmakers making these fantastic laws and employers that have to now strategically deal with it, right? So here we are.
Yep.
Any other honorable mention? Minnesota was one I wanted to talk about real quick. The state that authorized the use of edibles before they even authorized the adult use of cannabis. Any quick comments on Minnesota, Bill?
Well, very interesting. They said that you could only use or take per dose 5 grams or milligrams, I think is what it was, of marijuana, and per pack only 50. I think it was, but they didn't put any limit on how many packs you could buy, which is, it's like, okay, have fun. So Minnesota is a very complicated state. What the legislature essentially did was they not only provided off-duty protection of marijuana users, but they amended the state's very complicated drug testing statute, Section 181. And so you have to be real careful to look at the latest version of the state's drug testing statute, Section 181, before you take action, because there were many sections that were changed under that law in terms of who can be tested on a random basis and so forth, what the consequences might be of a positive test. And one of the most important things that was done was that for medical marijuana patients in Minnesota, they can use as an explanation of a workplace drug test, they can use the fact that they're a medical marijuana patient. All right, it's already been argued in court. What that means is that a positive medical marijuana patient should be reported as negative if they have a positive for marijuana. We'll see. We'll see how that continues to bear out in the courts.
Yeah. So hopefully we're driving home the point that these laws vary dramatically. So it's incredibly critical for you to understand the laws at the state and municipal level, and of course the court decisions as they all kind of collectively become the law.
Yeah.
Right?
And by the way, if you're wondering where in the world do I get information on these various states' laws, we have and can make available to you through Chase, we have an employer guide to marijuana for every single state.
Yep. Yep. And our friends at Chase are fully aware of those resources. So make sure you're engaging with them, and happy to reach out and help you navigate these by state so that's more applicable to your program. Now, we talked about the shift in testing for the prohibitions and testing for non-psychoactive cannabis metabolites. And that really came largely out of two big time state laws in California and Washington that went into effect this year, where the actual language in the laws prohibited employers from taking adverse action on a drug test that contained non-psychoactive cannabis metabolites, essentially changing how we drug test for cannabis going forward.
Yeah,
Where I sit in Washington State, the law only applies to pre-employment drug tests, but in California, it applies for all reasons for drug tests.
As well as Connecticut. And just so you understand how impactful this is, What we test for currently using urine is a non-psychoactive metabolite of marijuana.
That's right. And we'll have you do a quick science lesson on that
Yeah,
to dig in a
we'll
little bit
talk
more.
about it in depth in a minute. Yeah.
But it's absolutely changing the way that employers are allowed to screen for cannabis, or in most cases, what disciplines they can impose based off of the details of that positive drug test. If I look into the legislative findings here in California, Bill, do you want to cover just
Yeah,
briefly what they said?
we found some of these legislative findings fascinating, quite frankly. And you probably should realize that Nick and I were asked to comment and report to the legislator who was writing the bill. And of course, he ignored everything we told him. But among the legislative findings we found fascinating was the fact that they determined that THC, or tetrahydrocannabinoid, which is the active component of marijuana, the psychoactive component, is the chemical compound that creates the impairment. That was one of their findings. They also indicated that the intent of drug tests is to identify employees who may be impaired. That was never the intent of drug testing from the beginning in the late 1980s. It was always intended to identify those who may have used an illegal substance. So it's changed dramatically.
Yeah.
They also indicated that as science has improved, employers now have access to multiple types of tests that do not rely on the presence of non-psychoactive metabolites. Well, that's just flat out not true.
I want to know what their source was there, because at the time of this legislation, there wasn't the ability to do that, right? And in large, oral fluid testing was available, but majority of the collection sites and collection providers in the state of California did not offer it as a service. So I really was curious to see where
Yeah.
they got their information from.
Yeah, we're finding that they're still scrambling to find appropriate testing methodologies.
Yeah.
But the government code now has been changed. Section 12954 indicates that it is unlawful for an employer to discriminate against it. Note that it says discriminate, not test. To discriminate against in a person in hiring, termination, or any term or condition of employment, or otherwise penalize a person if that discrimination is based upon one of the following. One, essentially, the person uses cannabis off the job and away from the workplace, period. Okay, this paragraph does not prohibit an employer from discriminating in hiring or terms and conditions of employment, or otherwise penalize a person based on scientifically valid screening methodologies, okay? Or an employer required drug screening test that has found the person to have non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids, okay? So that's a lot to take in, and you really
It's a
need
lot
to
of
sort
legalese that
through
we
that.
now need to navigate in the testing sector of how we go about doing things. So, California, as you mentioned, Bill, we worked with the lawmakers there and provided our input, and of course they scrapped the majority of it. There it was one safety sensitive exemption that was adopted by the lawmakers there for the building and construction trades. They are exempt from this law. Those, of course, that are operating under a federal contract or grant. Of course, the lawmakers didn't go on to define what building and construction trades means. And I know that they're evolving the law right now to likely include law enforcement, first responders, those types of things. But otherwise, there are no other safety sensitive exemptions in California's law.
Yeah, what we tried to get them to understand was that the best approach may very well be that approach that was taken by Nevada, which essentially says safety sensitive positions are those which employers define as safety sensitive.
Right. And then where I sit here in Washington, a very similar law went into effect the first of the year as well. Again, limiting the screening for non-psychoactive cannabis metabolites. As I mentioned earlier, this law is specific to only to pre-hire, pre-employment drug testing. All post-employment drug testing, you can still screen for cannabis metabolites. But the state of Washington had a little bit more robust safety-sensitive carve-out. Of course, you have your first responders, you have the airline industry in here, but letter G, all the way at the bottom there, provided a general safety sensitive carve out for which impairment while working presents a substantial risk of death.
Now,
And
what
of
is
course,
that?
Safety
Yeah.
sensitive positions must be identified by the employer prior to their application for employment. What they're saying there is you must have a comprehensive job description identifying safety sensitive job roles, and you must post it in your job posting that it is a safety sensitive position. So
Well, there are certainly many, many more safety sensitive jobs that don't create a risk of death. But anyway,
we digress.
get,
Okay,
don't
Bill.
get me
So
started. Don't
so
get me.
taking a risk here to have a lawyer give us a quick science lesson, but talk about how cannabis breaks down in your body.
Well, I did own a laboratory once, or part of a group that did. So, not that I'm qualified to describe this stuff, but essentially, what's important to understand these days is how marijuana works in the body. As I indicated, it's really not appropriate anymore to simply say I got a marijuana positive. It's like, oh, what metabolite are we talking about here? As you use marijuana, it breaks down in the body to first what's known as delta 9 delta 9 tetrahydrocannabinoid, but that disappears from the body, from detection at least, within 1 to 8 hours. Okay, it's gone, can't find it. That breaks down, however, into another metabolite called hydroxy THC. Hydroxy THC also stays in the body a very short period of time. Studies indicate anywhere from 12 to anywhere from 2 to 12 hours. That hydroxy THC breaks down further into what's known as carboxy THC, which can attach to body fats and stay in your body for days, sometimes weeks, depending on the circumstances. So it's important to understand how short some of these metabolites stay in your system. Why? Because only delta 9 and hydroxy are psychoactive. Carboxy is non-psychoactive. So in California, you can't take action if the result you got was a carboxy THC metabolite. Okay, you're going to get that if you're testing using urine. Urine cannot identify delta 9. So what do? Well,
Yeah.
Nick, tell the audience what they do.
Yeah, no, that's why we're big proponents of oral fluid drug testing because you're right, Bill. Over the last 40 years or so, we've been looking for the presence of past cannabis use. So they've been targeting carboxy THC because it's easy to find and it sticks around. Now, when you have the language of the law changing to more recent use or trying to correlate use while at work, that detection time period now needs to shrink. And oral fluid, other than blood, is the only way to accomplish that goal. Um, we talked about how the historical change from looking now from past use to now the presence of illicit substances. Most drugs of abuse have a very short detection time period. You mentioned, Bill, the onset of THC. That's going to vary whether you're smoking it, where you're going to have an almost an immediate onset to a longer or a shorter duration. Where if you're using a gummy or an edible or something like that, it takes a little bit longer for you for it to kick in, but the high lasts a lot longer, so it sticks around a little bit more. Um, so again, testing is changing now from simply trying to find past use via urine and hair and other traditional methods to now correlating more recent use, which again, oral fluid or blood are the two options there. We know that for the fact that those are the two options that can identify delta 9 THC specifically, and hopefully thus bridge your legal gap, not to determine if someone's under the influence or impaired, but you can bridge that gap while at work.
Yeah,
Um,
let me just make one point before I forget it because I'm old. Um, you want to be really careful here because even if you're not in Washington or California or Connecticut, if you if your company policy says you'll be disciplined if you are found to be impaired, okay, da 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 da. You better be really careful how you test for marijuana, because if you test for marijuana and all you found was carboxy, that's not an impairing metabolite.
it used to be a slam dunk, but those days are essentially changing really, really quickly. And you
So
look at the
look,
different look at the different detection methods that were commonly used in workplace. Of course, hair to look for historical use, urine, the most commonly method used today, but again is looking for carboxy THC. Blood and saliva are going to be the solution here. Obviously, saliva winning as far as oral fluid is concerned over blood because it's less intrusive and less costly. We know there was a concept out there of detecting, looking to try to detect cannabis use via breath. I think a lot of the science is starting to complicate that issue and challenge whether or not that's even possible. But typically with saliva, you have what some people will quote, uh, different time limits. Our friends at Buzzkill Labs, an outfit out of California, are working hard to bring a product to market that narrows that window down, Bill, to what, like 4, 5, 8
Three,
hours?
3.5 to 4 hours.
Depending on the cutoff level used. So as they integrated chromatography technology in with oral fluid testing to create a more sensitive oral fluid drug test. So again, as these products evolve and solutions evolve, we'll make sure we keep everybody in tune to that.
Yep.
Now, we'll have to fly through some of these, but we want to make sure that we had some time to give you guys some new testing strategies as we talk about how this is changing. And it is more impacting more than just employers in Washington, California, Connecticut, and those we talked about. Because again, the implied laws in what you said, Bill, 28 states that have some kind of legal language that define or off-duty use or use while at work. This is going to become incredibly important.
Absolutely.
So again, don't be discouraged by these laws and simply say our answer is going to be to stop screening for cannabis so we don't violate these laws. As we saw about post-accident drug testing, the post-incident rates, positive rates for cannabis testing increased. That's a direct cause and effect of employers kind of just ignoring the issue pre-hire. From a pre-employment perspective, marijuana is still permissible to test for, with only a few state or municipal exceptions to that law. Um, Limitations may exist on what testing method you utilize, or of course, what actions you can take based off a broad positive drug test. But those laws are essentially your blueprint for how to apply your program where it's limited. So we definitely encourage employers to review the different specimen methods that are available, the different testing solutions, instant testing versus laboratory-based testing, determine what best will work for your company's specific needs. Um, and again, for medical marijuana pre-hire, again, don't blindly refuse to hire somebody because they state that they're a medical marijuana user. Make sure you're prepared to engage in that interactive conversation prior to taking any adverse employment action. And then on the post-hire side, for post-employment testing, employers should plan to have a very robust post-hire testing program that includes things like reasonable suspicion, post-accident, and random drug testing, especially in those states that are prohibiting testing for it pre-hire. Uh, again, we're going to harp on the fact that post-employment or sorry, post-accident drug tests were positive for marijuana continue to increase. I see that stat continuing to go up and to the right. Also important to note, there are some situations where employers must still continue to screen for marijuana. We talked about federal DOT programs for those employees that perform a federally safety sensitive regulated job must still continue to be tested for cannabis use. You may be required to still test under federal contracts or grants, or maybe a collective bargaining agreement, or in compliance with state voluntary drug-free workplace laws. So again, it's important to understand when and where, why, and how. But make sure you remain compliant. Make sure you stay ahead of these. And uh, as Bill mentioned earlier, don't just look at the federal, state, and local levels, but also make sure you're considering case law as well. Now, talking real quick about oral fluid drug testing, because again, we believe that there is going to be a big shift, and I think it's already started from employers utilizing urine drug testing and more utilizing oral fluid drug testing because of its many benefits and advantages. The first and foremost, it's got a shorter detection time period for it's a great solution for determining the more recent use of a prohibited substance. It can be detected in oral fluid minutes after first use and for a few hours after. It is also an incredibly easy, quick, and far less intrusive collection experience. We're not dealing with urine. Uh, you're just simply collecting someone's saliva. And also a huge advantage is that oral fluid collections are always directly observed, thus eliminating the opportunity for someone to substitute, adulterate, or try to cheat their drug test. And we saw that urine drug tests the cheating surged over 633%. Well, here's an immediate answer to that. Since oral fluid drug tests are almost always directly observed, it almost virtually eliminates the opportunity for someone to cheat that test. And I think legally speaking, most importantly, oral fluid has the ability to identify the parent drug of THC, Delta 9 THC specifically. It meets the letter of the law for those states that are limiting employers from taking action based on a non-psychoactive cannabis metabolite. And oral fluid drug testing has been utilized in workplace drug testing for years. Of course, on the non-regulated side, we do want to make sure that you understand that some states specifically define what specimens are authorized under state drug testing laws. So that could limit your use of oral fluid testing. Some states also limit the use of instant, rapid, or point of care testing devices. And also making sure you understand that there may be differences in cutoff levels between rapid testing devices and lab-based testing devices. So
yeah, people should remember that there are 31 states with mandatory drug testing statutes.
you know,
And they may define safety sensitive, they may define specimen, so you've got to be really careful.
that's right. And then I'll wrap up that conversation with oral fluid that the DOT has also approved and vouched for the scientific validity of oral fluid testing. In fact, they've approved it as an alternative specimen method for DOT testing programs. Now, a big note there that DOT, it's all on hold for the use of oral fluid drug testing until we've established the device and the laboratories are prepared for it. So it's all on hold right now. But with HHS and the Department of Transportation vouching for the legitimacy of oral fluid testing is huge when it comes to defensibility in workplace drug testing. And then lastly, the importance of job descriptions. While it may seem like a rudimentary HR task, job descriptions are holding far more weight than they ever did before, especially for those employees that you're going to be considering safety or security sensitive. In order to take advantage of those safety sensitive carve outs that exist with these marijuana laws, you're going to have comprehensive written job descriptions for each of the roles within your company that describe the essential functions of the job, that detail why that job is going to be considered safety sensitive. You can't just say that all of our people work in a warehouse, so we're all safety sensitive. That's not going to fly, right, Bill?
No, I mean, you got Supreme Court decisions in both Minnesota and Iowa in the last year or so that have said it's not the environment that determines safety sensitivity, it's the job function.
That's right. So it's incredibly important to make sure if you haven't done so already, or if it's been a while, go dust off those job descriptions. Make sure you've defined them by each of the roles within your company and that you're prepared to defend yourself, not if you're ever challenged, but when you're challenged in the court of law on your stance there. All right. So we're going to kind of summarize our conversation with some guidance and action items to hopefully help you navigate all of the confusing and scary stuff we just got done talking about. Of course, overarching everything is our friends at OSHA and the general duty clause requiring employers to provide a place of employment that's free of recognized hazards that are likely to cause death or serious physical harm. I think we could all agree that cannabis is an impairing substance and definitely has no place in the workplace in that respect. Again, to recap, clearly understand the language of the laws uh, and court and agency decisions that apply to the programs that you operate in all the states that you operate in. Make sure you're addressing that individually. Make sure you have a written job or written policy in place. If you haven't reviewed that and updated that in the last year or so, it's likely out of date and needs your attention. Make sure there's a clear stance in there regarding how you're going to handle marijuana as an issue and what consequences will be imposed for policy violations. Also, make sure you've looked at the different methodologies that exist. And of course, keep up to date with all the regulatory changes as this stuff is changing at an incredibly rapid pace. Make sure you've designed and implemented sound processes and procedures that complement the language of your company's policy. Give the tools, standard operating procedures to your managers and supervisors so they know how to enforce your company policy, especially in those heat of the moment situations. And remember that you can take a look at the different methodologies that are available and the different products that are available out there, and you can change it up. You can use different methodologies pre-hire versus post-hire, which completely makes sense in our opinion if you're looking for historical use pre-hire and more recent use post-employment. Certainly may be appropriate for you to look at those different opportunities and how you apply those differently in those situations. Make sure your managers and supervisors are trained on your substance abuse policy and what the procedures are. You're expecting them to enforce this, they should certainly understand it, right? And please, please, please train them on how to recognize the signs and symptoms of substance and alcohol use, and most importantly, what action steps to take in those moments. And incredibly critical, and quite frankly, Bill and I's opinion is the best tool an employer can provide and best investment they can get in their company is providing supervisor reasonable suspicion training, using someone's common sense to identify possible impairment, documenting it, and then justifying a substance abuse test is invaluable right now.
Absolutely.
And again, I'll harp one last time on job descriptions. If you don't have them, make sure you put that on your to-do list. Make sure you define it by each of the job roles that you have, especially for those jobs you're going to be classifying as safety sensitive and trying to leverage some of these safety sensitive exemptions to these marijuana laws. Make sure you're prepared if you're ever challenged. And then, of course, finally, regarding medical marijuana, make sure you're prepared to engage in an interactive conversation with those individuals to determine if their underlying medical conditions can be reasonably accommodated or not prior to taking any adverse employment action. All right, Bill. Sorry we had to rush that last couple of slides here, but I know there's a bunch, excuse me, for us to talk about. We talked about marijuana issues, some state laws. You mentioned the mandatory laws that are out there and voluntary laws that are out there, but again, our wheel of compliance here. Marijuana issues are just one thing that you guys have to stay focused on. These are all the different topics that Bill and I track on a daily basis, and most importantly, determine and decipher what the impacts are to our nation's workforces and how to practically comply with that. So, I promised a few minutes at the end to answer your questions. Certainly want to again thank everybody for listening into today's presentation, for sticking with us till the end, and thank you once again to the Chase team. They are waiting, ready to help you guys out, get compliant and stay compliant. So make sure you reach out to their Rockstar team, who we work very, very closely with to make sure you guys are understanding what these issues are and more importantly how to address them and to set up your program strategically to be successful and compliant.
I'll just say that it's a lot cheaper to be in compliance than it is to defend a case.
That's right. Okay, Bill, one question I got for you. So we have a multi-state employer based in Minnesota, but have remote employees in 13 other states. How do we address this from a policy perspective?
It's one of my favorite questions, because if you ask a room of 10 lawyers this question, 9 of them will jump out the window and the 10th guy's just too damn stupid to jump. This is a very complicated question. And I'm sorry that you brought up Minnesota, because they've got an oddball court decision in Minnesota that changes the norm. Let me just say that. Bottom line is that there's going to, in any dispute, there's going to be a hearing to determine which state's laws apply. And if you've got 2 or 3 different states' laws that could impact the rules that apply here, the court's going to look at the states that have these most significant contexts. That's the terms known in the law, most significant context. Bottom line is it entails the employer's home state, the employee's state of residence, where the contract of employment was made, where the work's being done. Our research shows essentially it's going to boil down to where is the work being done. Now, there's a difference between those who are residents of the state where the work's being done and the work is being done there versus somebody from Minnesota going to South Dakota for a temporary assignment. They may not, it may still very well be Minnesota's law that applies in that situation because they're only a temporary employee. But you have to look to all of those elements to determine which state's law is going to apply. The way we approach this, frankly, is we have a core company policy, and then we provide state-specific addenda. so that we cover the rules of the state in which you are operating and where the work is being done.
It's a,
It's a very complicated.
it's a great strategy. And as a lawyer, I guess I probably shouldn't have teed up that question to you. I probably should have answered it because you could have said it just depends, right? I'm just kidding. But to your point, if you're a company in Texas, for example, that have very limited or no laws really impacting workplace drug testing for the most part, but you operate in different states like Minnesota or California or others that have mandatory state laws, it is important for you to have a core company policy, the kitchen sink, as we call it, but then address state-specific issues by state so that you're making sure you're not missing out on what those are. Because gone are the days of a nationwide zero tolerance company policy. If you have one of those in effect today, you're in trouble, and we need to talk.
Yep.
But all right, that puts us a minute past the hour. I want to be respectful for everybody's time. For those questions that came in that we weren't able to address, we'll reach out directly. And again, make sure you contact your Chase safety team. They have all the answers. They have us on team as well, so they can help you guys navigate these issues, stay ahead of these issues, and most importantly, stay compliant. Thank you, everybody, for joining us today, and we will keep in touch. Take care.